Let's come back from the lunch break, please. When we broke for lunch, Mr. Rankin was asking his questions of division witness Brandon Powell. I know, Ms. Nanasi, you said that your witness would be available at 1 p.m. Going forward from that time. I would certainly prefer not to interrupt, a witness to take another witness. Is your witness available as well tomorrow if we couldn't finish her today?
No. She has prior commitments, which is why I asked for this time certain, from 1 o'clock all the way till the public comment. And so I'm wondering if we could finish with Namoga, and if there's a chance that somebody else could do cross-examination of Mr. Powell. And then at 1 o'clock, we start with Dr. Hanson.
Okay, parties. It's a small window.
Madam Hearing Officer, I defer to the division as Mr. Powell is their witness. I think having the questions fresh in the commission's mind might be helpful to have them be able to question Mr. Powell, but I leave it to the divisions. It's their witness.
Madam Hearing Examiner, I don't think it's ideal. Mr. Powell is available for the rest of the week, and we serve at the pleasure of the commission. So I do, my only contribution would be that based on previous questions and the amount of material that we covered, I do expect that, I won't speak for the commission, but I do expect many more questions for Mr. Powell. I think this is going to go for a while. So if it's absolutely necessary and the commission, this is what the commission wants to do, we will accommodate.
All right. Yeah, I think the commission, based on the previous questions they've had of previous witnesses and some of the discussion there, that there will be extensive questioning by the commission of Mr. Powell. All right, let's keep going, Mr. Rankin, and we'll find a good stopping point around 1.
Madam Hearing Officer, thank you very much. Commission, members of the commission, good afternoon. I've had an opportunity to review my copious notes. I believe that Mr. Tremaine has elicited most of the questions that I myself would have asked. I believe I've covered all the topics that I had intended in my cross, so I have no further questions of Mr. Powell. I appreciate the opportunity.
Thank you. Mr. Maxwell, do you have questions of Mr. Powell?
Your Honor, I do not. Thank you.
Okay, thank you. I saw Ms. Kessler in the room earlier. I don't see her right now. She may be on the platform. Ms. Kessler, if you can hear my voice, do you have questions of Mr. Powell? Okay, let's move then to Ms. Nanasi. Ms. Nanasi, do you have questions of Mr. Powell?
I do. I don't think that I will be able to finish within 25 minutes.
Let's
okay.
Make good use of this time.
Excellent. Good afternoon, Mr. Powell. First, my name is Marielle Lanassi. I represent New Energy Economy. Good to meet you in this setting. First, I'd like to discuss the statutory provisions governing OCD's authority. You are familiar with these laws, correct?
Generally, I didn't prepare anything for this hearing, but I'm generally aware of them.
And pursuant to 70-13-3, the statute says it is the jurisdiction of the Oil Conservation Division of the Energy, Minerals, and Natural Resources Department to regulate produced water as provided in the Oil and Gas Act. Is that your general understanding of that part of the law?
Yes.
This gives the OCD broad authority to make rules and orders to regulate produced water on the oil and gas field, correct?
Yes.
You are familiar with NMSA 1978, Section 70-2-12B7. Is that correct?
Not to memory, but it sounds like part of the Oil and Gas Act.
If it states the Oil Conservation Division may make rules and orders for the purposes and with respect to the subject matter stated in this subsection, that's sort of the broad 70-2-12B, and then there's many subsections. That's what your recollection is that right?
Yes.
Okay, and so Part 7 of that is, quote, to require wells to be drilled, operated, and produced in such manner as to prevent injury to neighboring leases or properties. Does that sound correct?
That sounds correct.
Do you agree that under 70-2-12B7, the law gives the OCD broad authority to make rules and orders requiring wells to be drilled, operated, and produced in such a manner as to prevent injury to neighboring leases and properties?
I'm not a lawyer, but I would say in whole, it would contingent on the other parts of the Oil and Gas Act.
And I'm not asking you as a lawyer, sir. I'm just asking you in your capacity as the director.
I understand that.
Okay, thank you. Referring you now to 70-2-12B15. The Oil Conservation Division may make rules and orders for the purposes, quote, to regulate the disposition, handling, transport, storage, recycling, treatment, and disposal of produced water during or for reuse in the exploration, drilling, production, treatment, or refinement of oil or gas, including disposal by injection pursuant to authority delegated under the Federal Safe Drinking Water Act in a manner that protects public health, the environment, and freshwater resources. Does that sound like what you understand Section B15 to state?
Yeah, I believe you're reading it. And that sounds familiar.
As an expert for the OCC, can you explain what authority you believe OCD has under that provision that I just read to you to regulate produced water?
I would say I'm not an expert on OCC. I'm an expert for Oil Conservation Division, so I would flip those acronyms a little bit. As far as being an OCD professional, our charge is to enforce the rules that the OCC promulgates.
Okay, and with that caveat, and I thank you for that clarification, can you explain what you believe the OCD power to regulate produced water is?
The power to regulate produced water is through the rules that the OCC promulgates. So the produced water recycling rule, the spills rule, anywhere where produced water is used in the OCD's rules that have been promulgated.
And so that's a broad authority, the overarching meta rule, and then a more specific thing about how do we deal with produced water, whether it's with disposition or handling or transport or storage or recycling, treatment and disposal. That broad authority regarding produced water is under the OCD's purview.
Correct.
Referring you, Mr. Powell, to another section, which is 70-2-12B21. And this also says that the Oil Conservation Division may make rules and orders for the purposes, and then section 21 or paragraph 21 states, quote, to regulate the disposition of non-domestic wastes resulting from the exploration, development, production, or storage of crude oil or natural gas to protect public health and the environment. Does that sound correct?
Yes.
Could you please tell us, how do you define non-domestic wastes?
I didn't prepare that for this. I would say non-domestic wastes are handled, I believe, under 1915-35. That's going to be your pit liner, your filters, those kind of things.
Drill cuttings, right?
I don't know if those fall under the non-domestic or domestic. I would have to look through the rules. That's not something I prepared for this.
Okay. As an expert for the OCD, can you explain what statutory authority you believe OCD has under 70-2-12B21 to regulate non-domestic wastes?
Objection calls for a legal conclusion.
Yeah, I think I understand your questions of Mr. Powell as a regulator, but a lot of the questions have skirted on legal conclusions. So, Mr. Powell, you know how to answer that question, which is that you're not answering as a lawyer. To the extent you have some other answer as a regulator, for example, you can answer it.
My general understanding is Oil and Gas Act provides the overarching statutory language that the OCC follows in promulgating rules. So that would allow the OCC to promulgate rules, which then the OCD would enforce.
Perfect. So in this subsection, specifically 21, when it says to regulate the disposition of non-domestic wastes resulting from the exploration, development, production, or storage of crude oil or natural gas to protect public health and the environment. As a regulator, could you explain what your job to regulate the disposition of non-domestic waste? What does that mean?
I go back to, I think it's really hard as a regulator saying how I utilize that to regulate that provision, because that's not a provision I directly regulate. It's a provision that gives us authority to create rules. And to know what rules were created using that provision, I would have to go back and look through the rule book to see which rules were promulgated as part of that act. I would say for non-domestic waste is part 35. The exploration stuff, maybe part 36, which is your surface waste management facilities. But knowing extensively how the OCD uses that to enforce, we don't use that statute to do that direct enforcement. We use the rules promulgated from that. And each time we do rulemaking, we use what statutes are that overarching authority to promulgate the rule, but OCC or OCD doesn't use the act as far as enforcement.
Okay, would your answer be generally the same for the last provision under that section, which is 22, 70-2-12B22, which states to regulate the disposition of non-domestic wastes resulting from the oil field service industry, the transportation of crude oil or natural gas, the treatment of natural gas, or the refinement of crude oil to protect public health and the environment? Would your answer be same?
Yeah, it would be the same. That's the overarching authority granted to the OCC and the division through the OCC for those rules. And OCD enforces the rules promulgated from that.
Thank you. Is it OCD's position that an operator shouldn't have to certify that it is not using PFAS contaminated produced water in its operations under this proposed rule?
OCD is not looking for a certification that they're using PFAS-free produced water under this rule.
Why not?
It's not seen as a chemical additive. It's also regulated specifically under 1915-29, which is the release rule that regulates produced water as a whole. And it's very explicit in its regulation of produced water. So therefore, we didn't extend that to this rule because it's already regulated by another rule. And it wasn't a rule that Wild Earth Guardians proposed to modify as part of this rulemaking. So it wasn't under the purview of the OCD to look at that change.
Do you think that that is potentially a huge loophole, though?
I would say that produced water was specifically looked at by the commission under 1915-29 at that time. And the commission designated what produced water, when there is an impact, would be tested for. So it wasn't something that we looked into because it was already addressed by another rule.
Do you have an opinion about whether there is more PFAS in municipal treatment facilities versus produced water?
I have not studied PFAS in any of the waters.
It appears that NMOGA is concerned about the ubiquitous nature of PFAS in water. Whether the water comes from municipal treatment facilities or produced water, wouldn't it be easier to identify what chemicals are additive if the operators were required to disclose them up front rather than having to distinguish where the PFAS chemicals came from in the event of a spill or a well blowout or a well casing failure?
I think that would be extremely broad. For example, municipal water supplies are regulated by the Department of Health. If there's testing of those waterways, those things, that would be something that I would expect the Department of Health to do. Otherwise, potentially oil and gas would be testing for something that people may be drinking.
Do you know that PFAS laboratory analysis is expensive and time intensive?
I don't know that.
I'd like to propose a scenario. There's a well blowout, and then the OCD demands that all chemicals, including what NMOGA claims is trade secrets, must be divulged to the commission. And PFAS is detected in significant amounts. So just assume that scenario. If OCD sought to hold the operator accountable without initial disclosure, there may be a fight between the operator and OCD as to whether the PFAS contamination was additive in the fracking fluid or whether the PFAS pollution was inherent in the PFAS contaminated fresh or produced water, correct?
I'm sorry, I just need to object here. I'm gonna object to that question. One, it calls for speculation. Two, it's a compound question. And three, I'm not even really sure what's being asked.
All right. Mr. Powell, I certainly would instruct you not to speculate in your answer to the question to the extent, well, let me ask you, did you follow it? It was compound. Did you follow it?
I believe I followed it. To answer it, there would be a clarification I would need to make to be able to answer it, but I think it's what authorities OCD would take. And I followed that portion. So if that's what we're looking for, I can answer that.
All right, go ahead.
The first question I do need clarification on is you mentioned well blowout. We're talking well integrity. A well blowout, it potentially is something entirely different. So I would ask, if you want it for a well blowout, what kind of event are you talking about?
Okay, well, let's do what you just said instead, well integrity.
Okay, so if there's a downhole well integrity event and there is an impact to water, OCD has jurisdictional powers under the Oil and Gas Act for subpoenas, request investigations. So ultimately, if the operator is fighting OCD, the director, I believe, has emergency powers to take action. And then there's also enforceability powers that the OCD has that they can take.
Well, what I'm trying to get at is if that scenario were to happen and OCD did use its enforcement powers and did get at that time the operator to divulge the chemical constituents, whether they were alleged trade secrets or not, couldn't there be, or wouldn't this situation invite like a fight between the operator, and let's say there was lots of PFAS that were found, wouldn't it invite a fight between?
I'm sorry, I have to object. Again, I'm not sure what's being asked. When she says lots of PFAS being found, it's also a compound question. And I think the witness has already stated that he's answered the question to the extent that he can.
All right. So, Ms. Nanasi, if we could get to the question, perhaps more directly. Mr. Powell, do you have the clarification you wanted?
I did receive the clarification to provide the last answer.
All right. So this is a new question. All right. Go ahead.
If there was significant PFAS that was discovered, wouldn't the fact that there wasn't initial disclosure invite a fight between the operator saying, hey, this just came from the municipal water, we didn't add it?
I think under the OCD's proposal, looking for PFAS as a whole comes from the chemical disclosures that OCD would receive. So we would be testing that based on if it was disclosed as one of those chemicals. So if it's found, then I don't think it would be a surprise. And at the same time, I believe any like remediation efforts, those kind of discussions would be under Part 29 and Part 30. It would not be under this rule as far as evaluation, enforcement actions, and where to go with it would be under other rules.
In my scenario, wouldn't systematic initial disclosure actually be more protective for both operators and first responders, health professionals, and the public?
I don't believe so. As we stated before, this rulemaking isn't creating additional personnel for OCD to perform this. So even if OCD received all of those disclosures up front, OCD doesn't have the manpower to address those. We feel if that type of disclosure is being pursued, that needs to be a legislative proposal, which OCD could respond to and ask for additional personnel if passed.
And if the OCD felt that initial systematic initial disclosure was more protective of human health and the environment, couldn't the division go to the legislature like in a couple months and ask for some more money to make sure that you had proper staffing in order to regulate on behalf of New Mexicans' health and the environment?
I think at this point, OCD hasn't made that determination because roughly 2,000 wells are drilled every year. And we're talking completions, recompletions. Very few of those, if ever, have a direct impact to water or surface water, groundwater or surface water. So those notifications wouldn't be going to an impacted party in those scenarios.
But I'm not talking about notifications. I'm talking about initial disclosure of chemicals used in those in the downhole operations.
But that would be the initial disclosure. That initial disclosures would be unneeded in, say, 99.9% of the time.
I see that it's 12:58, and I would go into a different line of questioning if you want to switch.
Do you have
Thank
a
you,
lot
Mr.
more
Poe.
questions, or can you estimate?
I didn't number them, but I have 18 or so.
Okay. Well, let's turn then to Dr. Hanson. Do we have her in the room or on the platform? Mr. Powell, thank you very much.
Thank you. I do have an opening statement, Madam Hearing Officer, but we could wait. I could postpone that till after Ms. Hanson if you'd like, or
Yeah, let's move to Dr. Hanson. Oh, I'm sorry. An opening statement, which would, I think, probably help the commission get an idea of where you're headed.
correct.
All right.
May I approach, and I do have copies of it for,
The opening statement, I did
Yes.
distribute the hard copies of Dr. Hansen's rebuttal that you handed me earlier.
thank you. But this is a copy of my opening statement, which I would like to give to you and the commissioners, and I will give it to the corporate.
Yes, thank you.
May I proceed?
Yes, please, thank you.
May it please the commission, I am Mariel Nanasi, lead counsel and executive director for New Energy Economy. I would like to address certain issues with you. The need to ban PFAS, the importance of the definition of PFAS that Wild Earth Guardians, which I will be referring to as guardians throughout, proposes, and why full chemical disclosure is necessary to protect public health and the environment. But first, I'd like to address NMOGA's rather combative and disingenuous stance in this case. Right off the bat, NMOGA is challenging your authority. Never mind that the legislature has explicitly endowed this commission with the authority and responsibility to regulate produced water and non-domestic waste to, quote, protect public health and the environment, and to protect landowners and properties in, quote, such a manner as to prevent injury. What this means is that if you find that PFAS pose harm to human health and the environment because of its toxicity, mobility, and persistence, and PFAS contaminated produced water and non-domestic waste can cause the degradation, if not permanent contamination of property, then it is your regulatory authority to do everything in your power to ameliorate these dangerous threats. 23 states have done just that, and we should join them. This case raises the very critical question if a claimed trade secret, where secrecy is generally preserved for the sake of business competition, must yield to a more paramount concern: the health of our bodies, our waters, our water, and our communities. New Energy Economy submits that it must. Colorado and California have already made this sound determination. As Dr. Hansen, New Energy Economy's expert witness, stated in her rebuttal, quote, between 2010 and 2024, the numbers of self-reported spills by the oil and gas industry indicate over 10,000 instances of produced water spills, totaling over 1 million gallons of produced water spilled. Of those spilled, 187 reached a water course and 99 spills affected groundwater. Given that PFAS has been demonstrated to be present in produced water and the persistence of PFAS compounds in the environment, it is likely that essentially all the PFAS ever spilled in surface or groundwater during this 14-year reporting period is still present and mobile in the environment, or present in a living being, either in its original form or as a terminal PFAS degradation product. It is your moral and legal duty to disrupt the pathways of further contamination. Given that, according to the New Mexico Environment Department, 78% of New Mexicans depend on groundwater for drinking water, 81% of New Mexicans are served by public systems with water derived from groundwater sources, and over 170,000 New Mexicans depend on private wells for drinking water. The commission must embrace this opportunity to use its authority to protect New Mexicans and our water from even greater dangerous contamination. The public is counting on you. Number one, NMOGA's first objection is baseless. Well within the Commission's authority is the regulation of PFAS in non-domestic wastes and produced water. The Commission is authorized to prevent oil and gas waste from contaminating New Mexico and to protect public health and the environment. NMOGA's pre-hearing statement alleges that Guardian's application and proposed amendments seek to have the OCD regulate, quote, the generation as opposed to the, quote, disposition of non-domestic wastes or produced water, arguing that because Section 70-2-12B15 provides the Commission with the authority to regulate disposition and other activities associated with it, but doesn't specifically use the word generation in the statute, thereby OCD's regulatory authority is limited and may not act to regulate the, quote, generation of PFAS contaminated produced water. In other words, according to NMOGA, the OCD is free to regulate produced water once it emerges from a well, but cannot regulate or even learn the content of the fluid that becomes produced water that represents a threat to our health and the environment. No one involved in this proceeding, including NMOGA, is confused about the process that results in produced water and waste. Drillers use fracking fluid made up of water and chemicals, set off explosions underground to release gas and oil. What comes back out of the earth as a result is fracking waste or produced water, which includes all the chemicals in the fracking fluid plus whatever else comes up from below. NMOGA's position is that despite the Commission's explicit responsibility to regulate produced water and its explicit authority to regulate its disposition to prevent injury, protect public health and environment, it does not include the authority to regulate what goes downhole in oil and gas operations. NMOGA's position is wrong for several reasons. First, as this Commission understands, the only way non-domestic wastes or produced water exist is via oil and gas production. Guardian's application and proposed amendments do not ask the OCD to exceed their powers or exceed its statutory authority by regulating generation of produced water and non-domestic waste. Guardian's application and proposed amendments seek to ban PFAS contaminated produced water and PFAS contaminated non-domestic waste. How is that accomplished? By banning PFAS in oil and gas downhole operations. If PFAS is banned in downhole operations, then when produced water and non-domestic waste is disposed, handled, transported, stored, recycled, or treated, it won't contain PFAS. Even NMOGA concedes that the, quote, common understanding of disposition is the disposal or discarding of something, the power to make decisions about disposal. The OCD has the power to make decisions about produced water and non-domestic waste disposal, including what is in them and whether they are contaminated with PFAS. Second, NMOGA is trying to sow confusion when there is none. Pursuant to Section 70-13-3, the legislature gives OCD broad discretion to regulate produced water, and the OCD may make rules and orders explicitly pursuant to 70-2-12B7 to require wells to be drilled, operated, and produced in such a manner as to prevent injuring to neighboring leases or properties, to regulate the disposition, handling, transport, storage, recycling, treatment, and disposal of produced water during or for reuse in the exploration, drilling, production, treatment, or refinement of oil or gas, including disposal by injection to authority delegated under the Federal Safe Drinking Water Act in a manner that protects public health, the environment, and freshwater resources. 70-2-12B21, to regulate the disposition of non-domestic wastes resulting from the exploration, development, production, or storage of crude oil or natural gas to protect public health and the environment. and 72-12B22 to regulate the disposition of non-domestic waste resulting from the oil field service industry, the transportation of crude oil or natural gas, the treatment of natural gas, or the refinement of crude oil to protect public health and the environment. Third, it is beyond dispute that PFAS is a toxic substance that is harmful to public health and the environment, and Guardian's application and proposed rule amendments seek to ban PFAS used in downhole operations. Quote, NMOGA supports a science-based prohibition on the use of PFAS, unquote. How that is accomplished is important and a legitimate area of legal debate. But for NMOGA to challenge this Commission's authority to regulate PFAS with such sweeping language and via confusing and baseless arguments should be rejected. Number two, NMOGA's second objection is another red herring injected to confuse and sow doubt, and two is without merit. The Commission and Guardians understand the difference between produced water and non-domestic waste. NMOGA claims that, quote, WEG is attempting to implicitly or explicitly redefine or reframe produced water as either a waste or non-domestic waste through this rulemaking process, and any such attempt is legally and procedurally improper. Despite this baseless claim, Guardians is not trying to conflate these terms, redefine or reframe these different oil and gas waste streams. This bogus claim should be dismissed without further ado. Guardians is requesting a rule change to prohibit the intentional use of PFAS by the oil and gas industry in downhole operations so that there will be no further PFAS in both produced water and non-domestic waste. NMOGA is trying to create legal chaos, conflating two different waste streams when there is actually none. 3. NMOGA's third objection is Guardian's reference to the Colorado law that prevents any further PFAS use by the oil and gas industry and requires chemical constituent disclosures. NMOGA makes an obvious point. Legislative action is not equivalent to rulemaking, yet its point is irrelevant here. The vast body of scientific peer-reviewed science points to research about the health impacts of PFAS. Exposures to PFAS may lead to decreased fertility, development delays in children, and raise the risk of certain cancers, including kidney, testicular, and breast cancers, and more. Our body's immune and vaccine response and hormones may also be negatively compromised. Guardians points to Colorado laws regarding a PFAS ban and a chemical disclosure as critical precedent, not to confuse the difference between statute and rulemaking, but critically because the oil and gas industry just across the border has adapted to a PFAS ban and chemical constituent disclosure and continues to operate and profit. Quote, anything Colorado did or failed to do in its most recent legislative action is irrelevant to the present rulemaking, says NMOGA. Colorado's law is not irrelevant because it demonstrates that when our neighbor to the north required a PFAS ban and chemical constituent disclosure to protect public health and the environment, the oil and gas industry was able to accommodate the more stringent standards. There is no evidence that NMOGA has submitted that changes Guardians propose that the changes Guardians propose to ban PFAS and require chemical disclosure can't be accomplished here in New Mexico, or that the changes are not well within OCD's broad regulatory authority granted by our legislature. 4. NMOGA urges rejection of many of Guardian's definitions, but these are necessary to effectuate the proposed rules. I will not go through why each of these definitions are necessary to implement the proposed rule changes and their respective legal underpinnings. I will save that for briefing, but I would like to highlight one very important one that is critical for you to ponder as you go through this hearing process. That is the definition of PFAS. NMOGA urges the Commission to reject Guardian's definition of PFAS chemical, though this is the definition that has been adopted in 23 states and has been used by Congress by Congress in promulgating laws. Guardian's definition, which is the widely accepted definition, is PFAS chemicals means a perfluoroalkyl or polyfluoroalkyl substance which with at least one fluorinated carbon atom. Dr. Hansen testifies that the definition, quote, ensures an accurate understanding and monitoring of PFAS risk. Namoga argues for an extremely limited definition of PFAS in the rulemaking, an attempt to exclude thousands of toxic compounds in this class of chemicals from the rule. Again, Dr. Hansen testifies against both Namoga and OCD's definitions. She explains that their definitions are, quote, too narrow to be protective of humans and the environment. The specific PFAS used by the oil and gas industry are not pure compounds, but are available with measurable levels of residuals, impurities, and breakdown products. It is environmentally and chemically simplistic to say that adequate control is achieved using a definition only relevant to a particular industry. PFAS are exceptionally stable in the environment. Most are highly mobile. Recent research suggests that toxicity of PFAS compounds is additive. These characteristics of the class indicate a need for a broad, inclusive definition to describe existing and potential risk. Unquote. You will have a world-class expert testify before you. Dr. Hansen's research has been cited thousands of times by other scientists and researchers, and I urge you to explore why Dr. Hansen is emphatic about a clear and broad definition of PFAS and believes that inclusion of PFAS, even compounds lacking in robust toxicological information, is necessary. It is critical that we get this right, and Dr. Hansen's testimony provides the substantial evidence that you need to adopt a rule that is comprehensive and the most protective of human health and the environment, just as the legislature instructed is to be done. And this is last. Chemical disclosure is needed to verify compliance with the PFAS ban and to provide information necessary for risk assessments and monitoring by regulators, first responders, health professionals, and the public. As you are aware, Guardian's rule changes require the disclosure of all chemical constituents in downhole operations. That means the oil and gas industry would have to divulge their chemical ingredients, not their recipe. Why is this necessary? Number one, the stakes are high and we must disrupt PFAS pathways. The health of our bodies, our water, and our communities is at stake. Scientific studies have linked exposure to PFAS with high cholesterol, ulcerative colitis, testicular, liver, pancreatic, and kidney cancer, preeclampsia, liver damage, thyroid disease, decreased vaccine response, asthma, decreased fertility, low birth weight, delayed mammary gland development, developmental problems, effects on brain development, and diminished immune system response. As NMED Cabinet Secretary James Kennedy has repeatedly stated, given the toxicity, mobility, and persistence of PFAS, we must disrupt the pathways of further PFAS contamination because it is more advantageous to prevent PFAS pollution than to try and clean it up at enormous cost. Number two, right to know. One of the fundamental underlying policies behind the idea of environmental protection in this country is that the public has a right to know certain things, such as basic health information about substances and compounds to which our residents are being exposed. When regulations compel disclosure of such substances and health studies thereof, the public can actually better protect themselves by making an informed decision about whether or not they want to voluntarily expose themselves to such a risk or how best to manage the risk of involuntary exposure. Number three, accountability. Disclosure is the chief method of holding fracking companies accountable. With chemical disclosure, it is easier to identify and quantify chemicals that may be present in spilled fluid. Without chemical disclosure, one has to use non-targeted methods, which are harder to measure and do not allow for quantification until they are positively identified. In other words, with chemical disclosure, it is easier to know what you are looking for and increases the ability to characterize human health risk. Number 4, policy driven by science. Full chemical constituent disclosure will provide the agency and the public with more data. The more data we have, the better equipped we will to make scientifically based policy decisions to protect our waterways from contamination and protect the health of New Mexicans and our environment. I'll close by acknowledging that PFAS are a pernicious threat to wildlife and human health because of their long-term stability, non-biodegradability in the environment, biopersistence in tissues, and documented serious health effects. New Energy Economy thanks you, Madam Hearing Officer, and Commissioners for your attention to this extremely important matter. We would never want to look back at this moment and say that when we had the chance to reduce toxicity in the environment and reduce harm, that we did not act. And with that, I present you with Dr. Hansen.
Thank you, Ms. Nanasi. That was exactly 20 minutes. Dr. Hansen, do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Ms. Nanasi.
Please state your name and spell it for the record.
My name is Kristen Hansen, Kristenhansen.
Did you prepare direct technical testimony and exhibits that New Energy Economy has designated as Exhibit A?
I have.
Is it true and correct to the best of your knowledge?
It is.
If I were to ask you the same questions today, would you give the same answers?
I would.
Did you prepare rebuttal technical testimony and exhibits that New Energy Economy has designated as Exhibit B?
I have.
Is it true and correct to the best of your knowledge?
It is.
If I were to ask you the same questions today, would you give the same answers?
I would.
Could you please provide a brief summary of your technical, direct, and rebuttal testimony?
Yes. I support the ban on perfluoroalkyl and perfluoroalkyl substances, or PFAS, defined as a class of compounds, including chemicals with at least one aliphatic perfluorocarbon moiety. The EPA recognizes at least 10,000 PFAS, though experts in the field estimate the class includes up to 15,000, many of which have not been identified, much less characterized. There are 6 well-characterized PFAS compounds that the EPA has recently listed maximum contaminant levels for in drinking water. The list is limited to 6, not because these are the only 6 of 15,000 that pose a threat to human health, but because these are the compounds for which sufficient data exists to characterize deleterious effects to human health. Other members of the PFAS class are not well studied. However, emerging evidence suggests potential similarities in toxicity for many members of the class. Emerging evidence also suggests the potential for additive toxicity amongst different members of the class. That is, exposure to more than one PFAS may result in health effects greater than exposure to a single PFAS alone. The potential for additive toxicity is reflected in EPA's utilization of a health index when considering the effects of PFAS on water quality. The definition of PFAS should not be limited to those compounds for which there are specific analytical methods. Given the uncontrolled nature of PFAS manufacturing processes and the variety of PFAS chemicals in the environment, a definition limited to specific compound would leave the vast majority of PFAS unmonitored and uncontrolled. The production, utilization, and discharge of PFAS compounds includes significant PFAS impurities and residuals, all of which may be present in an overall formulation discharged to the environment. Many PFAS, as well as the PFAS impurities and residuals present in a PFAS product, contain a hydrocarbon portion which may undergo some level of degradation in the environment. The product of that partial degradation is a smaller, persistent perfluorinated compound that may have different environmental mobility and toxicity. These residuals, impurities, and degradation products, known and unknown, are covered by the definition I've proposed. A comprehensive PFAS ban will protect public health from apparent PFAS, as well as the impurities, residuals, and partial breakdown products. My proposed PFAS definition is not just my expert opinion, but is the definition adopted in 23 states and in federal legislation as well. I disagree with the non-scientifically based perspective that insufficient toxicology data for a particular PFAS should disqualify that compound from inclusion in the comprehensive ban. Such logic is characterized in social science as, quote, undone science. It's defined as, quote, areas of research that are of concern for members of the public, yet are not an area of focus for industry researchers, often due to deliberate or tacit avoidance, unquote. Many PFAS compounds pass through the placental barrier from mother to infant via breastfeeding. These are two examples of routes of exposure that have been toxicologically characterized for the first time in the last 10 years, although PFAS have been present in our consumer products and environment for over 50 years. The defining characteristics of PFAS is their environmental persistence. Many are highly mobile and many are biologically active. Many PFAS move quickly and widely from their point of discharge or disposal via air, water, dust, sediment, or biota. The potential for PFAS spills by the oil and gas industry on the ground or in waterways, volatilization of PFAS from surface ponds, spills, or discharge of produced water underscores the significant risk to communities and the environment. Any one of these PFAS exposure routes could lead to wider environmental or human exposure. It's my expert opinion that full chemical constituent disclosure is a necessary companion to the PFAS ban. This provision is necessary to verify industry compliance with the PFAS ban and to provide information necessary for risk assessments, monitoring by regulators, first responders, health professionals, and community members. Thank you for allowing me to provide this summary, and I look forward to further examination.
With that, Madam Hearings Officer, I move the direct technical testimony and exhibits of Kristen Hansen as New Energy Economy Exhibit A, and the rebuttal technical testimony of Kristen Hansen as New Energy Economy Exhibit B. And I do have for the court reporter a copy of both of those testimonies that I can tender to him afterward. And with that, Dr. Hansen is available for cross-examination.
All right, thank you. Are there objections to the admission of any E exhibits A or B? No. Okay, they're admitted. Thank you. Ms. Mulcahy, will you be doing the questioning?
Yes, thank you. Good afternoon, Dr. Hansen. Can you hear me?
I can, thank you.
Yes, thank you for being with us in the virtual world. We appreciate it. I'm just wondering, Dr. Hansen, you are not a toxicologist, correct?
That is true.
Thank you. I have nothing further.
All right, thank you. Mr. Maxwell, do you have questions of Dr. Hansen based on her testimony?
I do not have questions for Dr. Hansen. Thank you.
Thank you. Ms. Kessler? There you are. Okay. Thank you. Ms. Kessler shook her head no. Mr. Tremaine?
No cross.
All right. And Mr. Davis?
I have a few.
All right.
Hello, Dr. Hansen. My name is Tim Davis. I represent the petitioner Wild Earth Guardians. I have just a few questions for you. First, I wanted to know if you were familiar with a study that's was authored by Siegel et al., and it's entitled Investigation of Sources of Fluorinated Compounds in Private Water Supplies in an Oil and Gas Producing Region of Northern West Virginia.
I am familiar.
That's marked as Wild Earth Guardian Exhibit 53. Have you read this study?
I have.
And this was a study of wells in West Virginia?
Correct.
And there was some discussion a couple of days ago about this study, and I'm wondering if you could opine on whether and why you think this study from West Virginia would be relevant to the proposed rule.
Certainly. I read the study, and I feel like there are three main points that were brought out in this paper that are relevant to the discussion. The first is that the authors were able to demonstrate a link between PFAS concentrations in private drinking water wells and unconventional oil and gas. The second is that the authors measured non-targeted analytes, non-targeted PFAS compounds, that is specifically PFAS compounds that are not laid out by EPA methods, and in some cases found extremely high levels of these compounds in the private drinking water wells. I think that that goes to demonstrate the importance of having a very broad definition of PFAS so that we are looking for all the compounds that could potentially impact a water supply, not simply those that have been well characterized already. The third point that I thought was relevant is that as the authors tried to refine their model and understand the impact of unconventional oil and gas on private drinking water wells, they were hindered somewhat by the inability to know specifically what compounds the oil and gas industry had used. So since these compounds were uncharacterized or non-targeted, they used sophisticated analytical tools to develop an understanding of what the compounds are. But without having a specific compound named by the industry, they were unable to fully confirm those compounds. As a result, the accuracy and the fidelity of their method was hampered by this lack of information. So I think this also speaks to today's discussion in terms of the importance of having the industry be completely transparent with the chemicals that they are using.
And on that last point, I'd like to ask you a little bit about targeted versus non-targeted testing. Are you familiar with those terms?
I am.
So can you...
Oh, sorry, go ahead.
I don't want to interrupt you. Please go ahead.
No, I wasn't sure if you just wanted me to start or you had a specific question.
Oh, the specific question related to that is when you have a sample for analysis and you have full disclosure of what's in that sample, can you talk about the accuracy of using targeted testing on that sample versus a sample in which you don't have disclosure and you must start with non-targeted testing? Can you compare those two scenarios?
Absolutely. When an analytical chemist knows the compound that they are looking for in a targeted analysis, there is a standard available and there is an understanding of the structure of that compound. And so it's much easier for the chemist to go in and compare what they have found to what they know they are looking for. And it is the case that in the targeted analysis currently in methods that EPA has, there are specific standards that are available. In non-targeted analysis, when an analyst does not know what they're looking for, they have to use much more sophisticated analytical equipment and secondary clues to help them try and understand what a molecule can be. Even if structurally they're able to say that they know the identity of the compound, without having that absolute confirmation, it makes it difficult for them to provide accurate quantitative data. They need a standard of that material in order to measure exactly how much is present.
Is it fair to say that when you know what you're looking for, you can more accurately identify?
That's a much simpler version of what I said, yes.
Is it also accurate to say that when you know what you're looking for, you can use targeted testing to quantify a compound?
Absolutely.
You hit on this a little bit in your opening summary, but I just want to ask you a couple of questions about the toxicological data that we have currently on PFAS compounds. I believe you said there are 6 that you would consider that we have toxicological data on currently.
Yeah, and I mean, I want to emphasize, while I am not a toxicologist, I think that the statements that I'm making about toxicology are really, they're conclusions that have already been well developed by other toxicologists. So it's not work that I've done, but it is conclusions that are well understood in the industry. And yes, the the 6 compounds that the EPA has chosen to designate for maximum contaminant limits are compounds that I think are well characterized toxicologically.
And so the absence of toxicological data on the universe of PFAS compounds other than those 6 does not mean that the ones that are other than those 6 are safe.
Absolutely. The statement that there is no evidence that this compound is toxic does not mean that there is evidence to prove that it is non-toxic.
For the PFAS compounds that have been studied for toxicological purposes, those compounds have shown to be harmful to human health. Is that correct?
That is correct.
Do you think it's any coincidence that the ones that have been studied have all shown those harmful properties?
I don't think it's a coincidence. I think it's a very complex area to understand the toxicity. And as I stated, one of the things that toxicologists are studying right now and learning is that there are, in fact, even the opportunity for additive toxicological results amongst these compounds. It's very complicated to study them, and it's very complicated to study in general chronic toxicity, which is what most of these compounds impart.
And the body of scientific literature.
So I'm sorry, Madam Hearing Officer.
Yes, ma'am.
I'm going to object here because Dr. Hansen is not a toxicologist, and I don't mind her talking about stuff that has already been found in studies. I think perhaps she has the expertise to be able to read that. But once she gets off into opining on stuff about toxicology, I think that's outside of the scope of her knowledge.
All right. So, Mr. Davis.
I'm happy to ask my next question within the scope of the scientific literature that exists.
All right. Thank you.
Dr. Hansen, the current body of scientific literature around PFAS toxicity, does that tell us anything about additive toxicity?
The current body of scientific literature tells us that there is potential for additive toxicity. An example of how this is reflected is the EPA's decision to use a health index as part of their MCL drinking water guideline, which accounts for the potential of additive toxicity amongst 4 of the targeted PFAS compounds.
In the current body of scientific literature about the toxicology of PFAS compounds, does it tell us anything about sensitive populations like infants, the immunocompromised, pregnant people?
Yes, the current body of scientific literature does talk about those sensitive populations, particularly, for example, the gestational repercussions and also health implications for infants. That's something that has been studied relatively recently because, as you might imagine, that is a difficult population to study. And as a result of those studies, the toxicological literature reflects things like preeclampsia in pregnant people, as well as developmental challenges in gestation and immune suppression of infants, for example.
I'm going to ask you about another one of Wild Earth Guardian's exhibits that's labeled as WG Exhibit 88. This is a study authored by Zhang et al., and it's entitled Characterization of Produced Water and Surrounding Surface Water in the Permian Basin, United States. Are you familiar with that study?
I am.
And you've read this study?
I have.
With regard to the use of PFAS, what did you take away from this study?
I took away 2 main points. The first is that PFAS can be linked to produced water. The authors demonstrated the presence of PFAS compounds in produced water. The second thing that I took away is that this is an area that has not been studied and requires much more study. The authors used a small number of samples and spent a good deal of time in their text documenting how additional studies are needed to better understand this phenomenon of PFAS in produced water.
And the samples in this study were taken from New Mexico.
True, yes.
I want to ask you really quickly about persistence in the environment and breakdown of PFAS. You do agree that PFAS is persistent in the environment?
I do.
And can you talk about the constituents that result from the breakdown of PFAS? Specifically, I'm wondering if the constituents break down to further PFAS compounds.
Mm-hmm. So many PFAS compounds start off as molecules that have a perfluorinated component and a non-perfluorinated component. When those molecules are in the environment or in humans or biota, the non-PFAS component often breaks down, leaving a terminal, very persistent PFAS component in the environment. So an example of this that is fairly well known is that in the textile industry, the PFAS compounds that are used to coat a textile have molecules that are half hydrocarbon and half fluorochemical. And when those molecules leave the textile and end up in the environment, the hydrocarbon part of the molecule falls apart, leaving the PFAS. And in the case of 3M's textile, for example, that PFAS is a molecule known as perfluorooctane sulfonate that is probably present in over 90% of the blood of every human in the United States.
So when these PFAS break down, you often still have a PFAS after the breakdown?
Absolutely, yes.
And that new PFAS post-breakdown remains persistent in the environment?
Yes, it does.
Are you aware that this rule seeks to ban PFAS in downhole oil and gas operations?
I am.
And you're aware that it also seeks to ban undisclosed chemicals in oil and gas operations that are downhole?
I am.
And you also understand under current law in New Mexico that operators do not have to disclose all chemicals that they use downhole?
I do.
And you also understand that the basis for this proposed rule is to protect the public health and the environment?
I do.
Do you have experience with non-disclosure of chemical compounds
I do.
that are claimed to be trade secrets? Can you tell us about that experience and how it relates to protection of human health and the environment?
Certainly. I worked at the 3M company for over 20 years, and part of that time was in understanding and tracking fluorochemicals in the environment. Following my employment at 3M and reviewing documents that were released to the public as a result of litigation, I could understand more about what was going on around me at 3M at the time and also what happened historically. In 1975, researchers came to 3M and provided a detailed chemical description of a molecule they had found ubiquitous in the US population. They described that molecule to 3M and they specifically asked for disclosure of the identity of the compound. 3M refused. That compound had the identity and a standard of that compound been made available to those researchers in 1975, I can tell you, as an analytical chemist, they would have immediately been able to confirm the identity of the compound that was present in the blood of the population in 1975. As it was, 3M did not disclose that until 2000. The result of that is that 25 years of scientific research was delayed because of 3M's unwillingness to share that confidential information.
So if there was a version of the proposed rule in which chemical disclosure was only provided to regulators, would that also prevent the type of research that you say we missed out on from 1975 and forward?
Absolutely. If researchers don't have the details about the chemicals that are being used. They can't effectively study them. As an example, that paper we talked about at the beginning from West Virginia with contamination of private drinking water wells. That's absolutely true.
And you agree that there's a very limited amount of toxicological data on most PFAS compounds?
I do.
Again,
So full public disclosure would allow us to start doing more science.
Absolutely.
I want to ask you about Wild Earth Guardians Exhibit 8. In your rebuttal testimony on page 3, lines 9 through 12, you list 23 states that use the single fully fluorinated carbon atom definition. Is that correct?
That is true.
Have you looked at Wild Earth Guardians Exhibit 8?
I have. I've skimmed it.
And that's a compilation of state law definitions that define PFAS as a substance with one fully fluorinated carbon atom.
True.
Is that exhibit consistent with your understanding of the 23 states that have used that definition?
It is.
And is that definition consistent with the one you're proposing for this rulemaking?
It is.
Are you familiar with the precautionary principle?
I am.
Could you briefly explain what that is?
Sure. The precautionary principle asks people who are in the position of making decisions to encourage caution in decision making, especially when there is some evidence of risk. And with extremely persistent contaminants like PFAS, the precautionary principle is especially important. There is plausible risk to the environment and to human health based on what we know about this class of compounds. And so the precautionary principle would urge decision makers to make decisions cautiously and on the side of public health.
In the context of the precautionary principle, do you believe that the one fully fluorinated carbon atom definition is consistent with the precautionary principle?
I do.
And could you briefly explain why?
The one perfluorinated carbon atom is the broadest definition that we have of PFAS. And as a result, it allows us to look at the complexity of the class and to take into account the largest potential for risk to human health and to the environment. Putting restrictions on what that definition is just narrows the view of what we can control and what we can measure and what we can monitor. And we know this is a class of compounds that carries significant risk to humans and to the environment.
Do you agree that these PFAS compounds are harmful to human health and the environment regardless of the source?
Oh, I do.
So in your rebuttal testimony on page 2, lines 3 through 5, you state, it's the responsibility of the industry to control the use of both the compounds produced for their purposes and additional PFAS compounds that are part of that final formulation, including residuals and impurities. Do you remember that testimony?
I do.
That's an accurate statement of your testimony?
It is.
Can you explain a little bit what you mean by that?
Sure. The process by which fluorochemicals is produced is extremely messy and hard to control. And even in the best of circumstances, we don't produce one specific compound, even when we're targeting it. We end up producing compounds that come with partially reacted or unreacted components and other things that we didn't target, but that are present in those formulations. I could give you plenty of examples of products that we encounter in our everyday life. A product like Teflon, for example, leaves the plant carrying with it a whole series of impurities and residuals that pose human health risks. And those come out, even though Teflon is the product, what the consumer experiences is Teflon with these impurities and these residuals.
There's been some discussion about quote unquote background PFAS.
Mm-hmm.
That is maybe also could be characterized as PFAS that is just present in the environment. Are you familiar with that term, background
Sure.
PFAS?
Sure, yeah.
And so whether, let me start over, strike that. If an oil and gas company injects PFAS through a frac fluid into the environment, do you agree that that could be a potential pathway of exposure to PFAS?
Again, I'm going to object to any hypothetical questions about toxicology.
Right, that sounded like a toxicological conclusion to me.
If an oil and gas company uses a PFAS containing frac fluid and it's put down the hole, not asking you about toxicology, I'm asking you about persistence in the environment of the chemicals, mobility in the environment of those chemicals. So when PFAS is injected downhole from a frac fluid, could it remain in the environment?
Yes.
Could it move around in the environment?
Yes.
Now, if that same PFAS compound was coming from a background PFAS source, would it persist in the environment?
Yes.
Would it move around in the environment?
Yes.
I have no further questions. Thank you.
All right, thank you, Mr. Davis. Ms. Nanasi, do you have any redirect before I go to the commission?
I think I just have one question, and that was when, do you recall when Mr. Davis was asking you about failure to disclose means that essentially it would hamper the availability to do more science? Do you remember that?
I do.
It also, failure to disclose would also impair the ability to characterize human risk. Is that right?
It
I'm
is.
going to object on that. She's, again, not a toxicologist, and questions about doing human health risk assessments are toxicology questions.
Yeah, Ms. Nanasi, would you rephrase that, please?
To the extent that you know, based on your professional expertise, do you believe that failure to disclose would also impair the ability to characterize human risk?
Again, that's a human risk assessments are all in the field of toxicology. Those are toxicological questions and conclusions that you need to have an understanding of human health risk assessments, exposure pathways, and Dr. Hansen is not a toxicologist.
That was my understanding of her background was in chemistry, not toxicology.
Can I follow up on a question for a foundation then?
Go ahead.
Do you have an understanding of how risk has been characterized regarding PFAS?
I do.
And now to ask you again, to the extent of your personal knowledge, would failure to disclose mean that that would impair the characterization to human risk?
Yes.
Thank you.
Okay, is that it before I go to the commission? I'm wondering if it would help to take a short break before we begin with commission questioning. All righty, let's come back at 10 after 2. Let's come back from the break, please. We took a short afternoon break and we turn now to the questions of Dr. Hansen by the commission. Mr. Chair, would you like to start?
I would. Thank you, Madam Hearing Officer. Thank you, Dr. Hansen, for your testimony today and for appearing before us. We appreciate the information that you shared with us. Dr. Hansen, just to get clear, I know it's been harped on that you're not a toxicologist, so I got that much out of the testimony. If I understand correctly through your CV and through your testimony and rebuttal, you're an analytical chemist, correct?
That is correct.
Okay, so a PhD in analytical chemistry, is that exactly? Okay, excellent. Thank you for that. Doctor, I have a couple questions for you. And it kind of all revolves around PFAS, but let's start off. Mr. Davis had asked you about targeted analysis and if it's easier to identify the analyte if you know what's in the compound. And I think we understand that if we know that compound X is in the solution and the test can find compound X, it makes it easier for everybody. But if you don't know that compound X is in the solution and yet the actual analytical procedure does test for compound X, is it really that hard to identify compound X?
That's a good question. I think to separate it out, if you're looking for something that there isn't a standard for at all and you don't know what it is challenging. The paper that was cited is an interesting example of how they came to the identities that they did, and they had to use several complementary analytical techniques to develop that final answer. They use a technique, for example, called high resolution mass spectrometry that provides the molecular weight of the molecule down to the thousandth of an AMU.
Sure.
So it's not trivial, but it is possible.
So, and when we say high resolution, are we talking mass spec with a liquid chromatograph? What are we talking about?
Sure. As it sounds like you're familiar with these techniques. So certainly HPLC, and there's either high resolution mass spec just with one mass spec, or the mass spec, so you can look at the fragments of the molecule as well.
Okay. So, but again, if the analytical procedure in front of us tests for compound X, whether or not we know it's in solution makes no difference. You can still see compound X and you can quant off of compound X. And I apologize, I said quant because I do have some chemistry experience. You can quantitate off of that particular result, correct?
Yeah, if I'm understanding your question correctly, I think what I'm hearing is if a molecule is in solution and you have a standard that you're testing for, you can quantitate the level of the molecule in solution based on what you know with your standard. Is that what you were questioning?
Yeah, that's exactly what I was saying. So it's if our testing procedure can see a specific compound, it doesn't matter whether it's disclosed or not. It's still easy for the machine, the instrument to see it because you're already testing for it, correct?
Yeah. So again, let me just clarify to make sure I understand. So if you tell me I have a mixture here and I want to know what's in it, and I say, well, compound X is likely to be present in this mixture, whether you've told me or not, I can go in and look for compound X and find it because I have some other knowledge that tells me probably compound X is present. Is that it?
Yes. So in the questioning that Mr. Davis had given you, it was more the concern because your answer was it does make it easier to know if it's unknown. We're doing some screening. We're looking to find stuff. If we know that the solution has various compounds, it makes it easier on the screening, especially if the test is not necessarily a standardized test that's used across industry, like an EPA test, correct?
Yeah, I think so. Again,
Okay.
I think I understand your question.
Okay, I appreciate that. Second of all, You made the statement, and I value your statement as a chemist, that these compounds are harmful. And I definitely believe in that as well. Yesterday, we had an analytical chemist tell us that some of these PFASs are inert and really don't interact with anything. Is that statement, as an analytical chemist yourself, is that statement a correct statement? I'm trying to see, as a governing body here, the information that's coming into us.
Sure, absolutely, absolutely. So it's not something that I can answer yes or no. It requires a little bit more exposition around it. And that is that there certainly are examples of polymeric PFAS compounds that are inert. However, the production of these compounds, both where they're made at the manufacturing facility and how they are submitted as products, are rarely pure. They come with them with residuals and impurities in them. And I was trying to use the example previously of Teflon, for example,
Okay.
where there are other molecules that are riding along with that polymeric material. And those molecules may not be non-toxic, and they may be extremely mobile in the environment. So I think it's important to separate the fact that even though such a pure compound may exist, practically speaking, it doesn't really exist in the products that are purchased.
Okay, thank you for the clarification. That I appreciate it. Another thing that you mentioned, and you've relied on it, and other witnesses have relied on, is this Jang paper that was published in 2021, I believe, if I'm correct.
I think it's 22, but
22. Sorry, I was off by a year. My apologies. In looking at the Jang paper, and this was a concern I had yesterday as well, when we're looking at the PFAS information that was submitted, and if you have that paper in front of you, it's page 8 of that particular paper under 3.4 PFAS analysis. They did analytical sampling. They did analysis on samples that came from produced water and from the Pecos River. Now, Dr. Spear yesterday said he thought that they were 12 samples. I only read 2. I reread it yesterday again, and it was only 2 samples that they did, 1 and 1. Now, as an analytical chemist, and please correct me if I'm wrong, the results that they mentioned, especially for the produced water, they noted that there were 5 PFAS compounds that were found in the produced water, and they state the levels that they found them at. But then they also said that PFAS was indicated in the blank samples. Now, as a, I'm sure, tenured and professor that has authored professor yourself, would you base your data on something that also has PFAS in the blank? I mean, a blank's supposed to be 0, right?
It is, and yet within this area, as you can imagine, given the ubiquity of these compounds, that how to handle blanks in environmental analysis associated with PFAS is a huge area of study, and researchers really go to great lengths to define the limits of their blanks. And I hear what you're saying. There were some blank contaminations that the authors noted. Not every PFAS that was found in the blank. To me, the value of this paper, more than simply saying, oh, there's 0.25 nanograms per liter of PHXS, is more to say that there are fluorochemicals in this sample, and we need to do more testing. As you pointed out, one sample is not really sufficient to make any great conclusions on, other than to say this is an area that definitely needs more study, and the data indicates that there is at least a potential for risk that should be followed up on.
And I appreciate that. Thank you, Doctor. And again, I also agree with you because you said the paper brought two main points to you. One, that PFAS can be found in produced water, and two, that more study is needed. And I definitely agree with number two. I have a hard time. I appreciate that the authors actually wrote that PFAS was in the blank. Sometimes you don't get all that information. So I appreciate their truthfulness in this. But as a body, we're asked to kind of put our trust in or put some weight onto, not necessarily trust, but put weight into the fact that this was found. But it seems that as ubiquitous as PFAS is, unfortunately, it's in everything. You just have to pull it up and you can see what it's in. It's, I think, also very difficult to be able to say with assuredness when your blanks are also contaminated with PFAS that what you're finding is really from produced water. Also, the river had it as well. And they did not indicate whether the river blanks had PFAS in them or not. But in my mind, I'm trying to coalesce this paper to try to see how it's really supporting. And I'm reading it and I'm saying, yeah, the part I get out of it that I agree wholeheartedly is more research needs to be done. I can't really put myself and say, well, the blank has it. This could be systemic. They could have been using Teflon toppers on their vials. This could be the water was contaminated from some other source. There's a variety of things, but we're asked to definitely put all of our trust in it as if it's Bible. And I'm having a hard time kind of bringing these two things together. And as I said, you're the second or third individual that has based their information on this. And I don't see how, as an analytical chemist, you could tell me that these results are spot on.
I don't think I actually said that.
You didn't. You're right. You didn't. I'm just making that extrapolation. As scientists that are basing their data on this, you're kind of telling us, yeah, you should put trust in this.
Oh, I feel like maybe you've put some words in my mouth because I would never use the word Bible to say that this data, that reflects my belief in this data. I believe what I said is that this study, more than anything, demonstrated the potential for PFAS compounds to be present in produced water. And I think there is, although it's certainly the case that of the 5 PFAS compounds identified, I believe 2 of them were in the blank, but I don't believe all of them were.
Correct.
I also believe that the authors, for example, said that they didn't use Teflon caps, as you brought out. They did their best to control this.
As a matter of fact, I was trying to read that. Could you tell me where that is?
Can I finish my statement,
Yeah,
please?
And folks, one at a time, please.
Right.
Yeah, I thought I was talking, so.
My apologies.
So I would like to finish that and say that, again, there was some compounds that were not in the blank. And so the main point that these compounds, that this analytical work reflects the potential for PFAS to be present in produced water, which I think is what I said, and that it's an area that needs more study, is not negated by the fact that there is some PFAS in some of the blanks, and that it is in fact dealt with very professionally by the scientists in this paper.
And as I mentioned, I agreed with you on all of those, but we're still asked to put some trust in this particular, maybe you didn't say it, but we're being told that by 3 different people that this paper is something that we should put some trust in. And that's where I'm going on. Correct. You didn't say that it was the Bible. I'm saying as a whole, we're being told that we should follow this. So I appreciate your candor on that. The next part that I wanted to ask you is that on your exhibit, let me make sure I get it. On page 7 of your rebuttal, you state that the OCD definition is inadequate. It is too narrow and leaves many PFAS compounds unregulated. Can you expound on that for me, please?
Yeah, you're going to need to give me a second here.
Yeah.
It's on page, I'm sorry, of the rebuttal page.
Of your rebuttal, page 7, line 11. This is exhibit B.
I think I must have different I must have different page numbers. I apologize. So, but nonetheless, I can find it on here. The OCD definition, right. Okay. I know where this is. All right. Because the definition went on to suggest, for the purposes of completing environmental investigation, specific PFAS chemicals that can be included, and it listed several methods, several EPA methods. Those methods list several PFAS compounds, but not a complete list. I think I went through these methods and kind of loosely counted up, and I think all of the methods listed in this definition, taken comprehensively, include on the order of about 50 different PFAS chemicals. Given that, you know, the EPA recognizes that there are 10,000, 50 is a very small number. And so that's why I said that the definition proposed is too narrow.
Okay, my question then to you is, as an analytical chemist, can we see all of the compounds that the EPA is saying?
When you say C, do you mean like a list, or
do we have targeted analytical procedures for them?
No, I mean, that's the point, right? Because some of these compounds are not even characterized by the industries producing them. It's a very messy process. And so we are forced to rely on advanced analytical techniques, like, for example, high resolution mass spectrometry, to try and elucidate what these compounds are. But it's not something that is necessarily the case that all of these molecules have been adequately characterized such that they can be written into a method.
Okay. I have no further questions. Thank you. Thank you, Doctor. Appreciate it.
Thank you, Mr. Chair. Commissioner Bloom.
Good afternoon, Ms. Hanson.
Hello.
I'm Greg Bloom. I'm the Assistant Commissioner of Minerals from the Land Office. Thanks for your time today. Putting the JANG study aside of produced water in the Permian Basin, would you still have concerns about PFAS in oil and gas?
I do. I mean, and the other scientific paper that we spent some time on, I think, is actually a better example than the Jiang example, although I recognize the geographic proximity of the other is more relevant. But that other study, really, I think, even more definitively proved the risk and the potential between unconventional oil and gas and drinking water contamination. My main concern with these compounds is that they are so persistent. Anywhere they end up in the environment, they're there. It's not like you spill a cup of coffee on the carpet and you can just wipe it up. Once it's in the environment and it's moving, you can't go back and pull it in. So I do have concerns.
So you mentioned the persistence. Does the literature around PFAS toxicity also suggest that these compounds be banned from oil and gas production?
Yeah, I guess the toxicologists that I work most closely with are of the mind that we need to ban the use of these compounds for any non-critical use, in part because they go into the environment and they don't go away, and because of things that are around, for example, the additive toxicity. So it gets very hard to talk about the exposure of an individual when you have to take into account things like additive toxicity. What else are people coming into contact with?
You mentioned critical uses. What does that include? Just curious.
Well, the definition that I support on critical uses is something for which there is absolutely no other alternative, something that is very well controlled, both in the sense of how the fluorochemical is used, but also how the fluorochemical is produced. So as an example, there may be, for example, the need to use a perfluorinated compound on some component of a medical device. I don't have a specific example. I'm just using this in general. And in that case, the fluorochemical that is produced for that critical need for which there is no other chemical can be produced and cleaned, and all of the waste associated with that chemical from manufacturing until use can be controlled and captured and dealt with appropriately.
Thank you. Dr. Hansen, are you familiar with the spill data that Ms. Troutman presented from Wild Earth Guardians?
I am.
Any thoughts on that? Does anything there give you pause?
Yeah, I mean, as I put in my, I believe it was the rebuttal there, the spills that happen as a result of the oil and gas industry's use and the exposure then to surface water and groundwater is particularly concerning as it aids in the mobility of these compounds in the environment.
And I think lastly, is there anything in the literature about PFAS entering the air through oil and gas operations?
There is, and you know, there are examples of that both from flare-offs as well as from volatilization of PFAS from settling ponds and from spills.
Did you cite any of those in what you provided us?
I did not. Interestingly, I was reading about them last night, and if it's possible to like add those to you now, I could certainly follow up with that. But I did not cite any of those specifically.
Is that a possibility, Ms. Hearing Officer?
I would ask if Ms. Nanati would like to offer those. The other side of that is then the other parties have a chance to object to it. We kind of go through another round of, if you will, rebuttal. Any comments from the council here?
Madam Hearing Officer, I don't know if if Dr. Hansen can cite to at least the names of the studies that she's referring to, and that could therefore be dealt with like right now. So we could avoid what you just suggested might happen.
Any other comments? No.
Madam Hearing Officer, I'm just not, first of all, I don't think it's been properly noticed under this rulemaking. So I have that issue. Second of all, the commission doesn't have any jurisdiction over air quality. That belongs to the Environmental Improvement Board in New Mexico. And so I'm just not really sure of the connection here and how a discussion and rebuttal on air quality issues is appropriate.
It is a more attenuated connection here to the record we're making.
Yeah, I think I mentioned it because I think there's been some a presence in the record that PFAS can get into not only the earth and water, but also air. And we've seen that, I think, throughout the record, at least in a couple spots. I don't know that any further information on this would change my thinking on the case. So I'm fine to let this go at this time.
If I may, Madam Hearings
Ms.
Officer.
Nancy.
On page 9 of Dr. Hansen's testimony, she does specific line 7 through 12. She does specifically mention that the way that PFAS can travel is through volatilization of incompletely combusted PFAS during flare-off, volatilization of PFAS from surface ponds, spills, or discharges of produced water, and the presence of PFAS on and from surfaces and machinery encountered during transport, use, and disposal, etc.
Yeah. Okay. Thank you for pointing that out, Ms. Nancy. Commissioner Bloom, I think you have something on the record if you'd like to base some kind of conclusion on that sort of testimony. You just don't have the, if you will, the background research on that.
Yeah. Thank you. And let me check. I think that was maybe my last question. That was. Thank you. Thank you very much, Dr. Hansen.
You're welcome.
Thank you. Commissioner Ampoma.
Thank you. Thank you, Dr. Hansen, for being with us. I am Dr. William Ampoma, professor at New Mexico Tech. I do have a couple of questions. So in your Exhibit A, or the Exhibit A for new energy economy, on page 6, you made reference to EPA including about 6 PFAS compounds in their ruling. Um, I want to know, do you know why, do you have any knowledge as to why EPA resulted in focusing on these 6 chemicals?
Yeah, so this has been a very long process for EPA, and those 6 compounds, they felt that they had sufficient information on on both the presence of these compounds and the toxicology associated with these compounds, as well as enough data to understand a bit about the mechanism of action. And so it was quite a high bar, if you will, for these compounds to have sufficient data for EPA to choose to regulate them. There was plenty of people that wanted to include other compounds, and at this time EPA suggested that more data was needed. EPA also has a roadmap in place for PFAS compounds and committed to continually review the limits that they have put in place as more data becomes available.
Thank you for that. So then definitely you believe that they based their decision on actual scientific study, to back the decision that they made. Would that be a fair statement?
Absolutely.
Now you talk about the definition of NMOCD, the definition that NMOCD is proposing. So even you look at EPA, they are looking at 6. Now, from NMOCD's definition and based on the experts that they work with, they are thinking about, or at least based on their definition, they are looking at about 40 to 70 compounds. So don't you believe that even they've really tried to include more compounds?
Unfortunately, no. I think that when you consider that there are 10 to 15,000 members of this class, having the ability to monitor for 50 to 70 is not adequate to fully address the class of compounds. With EPA's decision to look at only 6 in drinking water and requiring a huge amount of toxicological data for those 6, I think that's very different than suggesting that there should be only a small subset of the overall PFAS molecules that should be monitored in the environment. As we discussed, most of these compounds, there is no toxicological data or insufficient toxicological data present for these compounds because the amount of scientific effort needed to develop those tox profiles is enormous.
So even when NMOCD, based on their definition, they say that the list will evolve as more scientific information becomes available. Is that still not sufficient, at least based on the current scientific knowledge?
Absolutely. It's, in my view, a backwards looking assessment of risk to say, when they're in the environment and we can detect them and they're showing up in people's drinking water, then we'll start caring about them, right? That's how I read that statement. I feel that this is an area that we need to be proactive in because, as I stated, once these molecules are in the environment, we can't call them back. And we are still understanding the various ways that they can additively or with other underlying health conditions cause repercussions for humans and the environment.
Are you familiar with any examples of PFAS that has been used in the oil and gas industry?
It's not something that is easy to find information on, but I have searched and I understand that molecules like Teflon, for example, and PTFE are often used in the oil and gas industry. As I've said before, I'm not an expert, so I'm gaining that knowledge just from what I read in the literature. I've also read that surfactants, fluorochemical surfactants, are also used.
Thank you. So with reference to Jean's paper, Professor Zhu, who is the corresponding author from NMSU, that paper has been referenced a lot, and the chair more or less alluded to this. Is there any other reference that you're familiar with that supports the claim that there is PFAS found in produced water?
I did do a literature search in preparation for this, and I could not find another peer-reviewed scientific paper. I did find reference it to fluorochemicals in produced water, but because they were not in peer-reviewed scientific data, I didn't consider those as I tried to learn about this. However, I guess my feeling was in looking for this is not that dearth of papers implies that there are no PFAS in produced water, but it is not an area that has been studied very much.
Okay, so in the pre-hearing statement of new energy economy, I just want to understand, or probably is it your understanding that produced water should not be used, in downhole operations? Is that your understanding too?
That is my understanding.
Okay, then let's go back to Jean's paper one more time. So in that paper, that same paper looked at produced water samples and then also looked at surface water samples from the Pecos River.
Mm-hmm.
Now, both samples, there were PFAS in that,
Mm-hmm.
right? And looking at the scarcity of water in the state of New Mexico, I mean, how do we say that let's say the commission should more or less not allow the use of produced water because probably there might be PFAS in there? It sounds like PFAS is everywhere. So can you comment on that?
Yeah, I guess my feeling is that there are low levels of PFAS in the Pecos River and other places for sure, that doesn't give us an invitation to continue to add fluorochemicals into the environment to raise those levels. So the Pecos River is an example of a water body that it's going to be extremely difficult to take fluorochemicals out of. We can't control that wild river now. We can control the compounds that we put into the environment that will ultimately end up in a water body like that river, for example. So I think it's important to distinguish between the fact that there is damage that has been done to the environment, but that doesn't mean we should continue to do more damage to the environment and say, it's a lost cause. There's fluorochemicals everywhere anyway.
The reason why I was making that point, I'm trying to understand, from NMOCD's point of view, they believe that, or let's say based on the testimony, PFAS can be within our municipal water. It can be in the surface water. So they want to really focus on additives that are added to downhole operations. So don't you believe that is enough, other than more or less putting strict restriction on produced water usage?
I don't, because I just think that the use of fluorochemicals in this industry, in produced water, but also in all of the things that happen along the way, for example, spills, for example, volatilization from settling ponds and that type of thing. There's a lot of opportunities for environmental contamination, as has been pointed out by other experts, that go along with these operations and introducing fluorochemicals into the environment. So that's why I think they need to be prohibited from the operations.
Thank you, Dr. Anderson. Thank you.
All right, thank you. Is there any reason not to excuse Dr. Hansen?
I do have one.
All right.
Sorry about that. Sorry about that. Sorry about that. Are you familiar with the frac focus?
Vaguely, I am.
Okay. Yeah. So I'm going to read some statement from the pre-hearing statement, and then I want to get your thoughts on that. That will be on page 8 of the pre-hearing statement. Lastly, as you are aware, guidance rule changes require the disclosure of all chemicals, constituents in downhole operations. That means the oil and gas industry would have to divulge their chemical ingredients, not their recipe. Now, I want to ask you, so they do disclose some information on the frac focus. So how do we do this? Let's say as a commission, how do we more or less enact this rule, and still maintain trade secrets provisions without a legislative change?
I think it's a very pertinent point that what is being requested is disclosure of the ingredients, as you say, and not the recipe. And so this isn't, tell me exactly how to make the fluids that you're using. It's just disclosure of the chemicals that go into those. I also think it's important to recognize that the designation of confidential business information is ostensibly put in place to protect competitive information from other people in the field. But it's my understanding that, for example, in Colorado, it's not allowed to protect this. So the competitors are already exposing all of their ingredients. And so it really seems to lower the risk for anything that is truly of proprietary value to be released to competitors if simply a chemical profile is shared so that the chemicals can be monitored by community members.
So when NMOCD says that they do not have the authority to support that, unless through a legislative change, what would be your response to that?
Yeah, unfortunately, I don't know enough about the legislative process to be able to comment on that.
Okay, thank you.
Thank you, Mr. Ampoma. Any reason not to excuse Dr. Hansen at this time? No? All right. Thank you very much for your testimony, Dr. Hansen.
Thank you.
Let's go back to Mr. Powell. Mr. Tremaine.
I do have some redirect for Mr. Powell, if that's possible, but I think
Actually,
sure.
you know what? Sorry, I just messed up. I just looked at my notes and I realized I messed up. Ms. Nanasi was questioning Mr. Powell. And then, of course, we go to Mr. Davis and the commission. Yeah. Right? Yeah.
Yeah, I updated it. You weren't doing that. Yeah, because we didn't change the slides.
Thank you, Sheila. Yeah.
Good afternoon again, Mr. Powell. Referring you now to page 1 of your direct testimony. You state at line 19, New Mexico has been very proactive regarding PFAS, and the OCD sees this proposal as the next necessary step in protecting the citizens and natural resources of New Mexico. Is that a fair reading of your statement there?
It is.
Can you elaborate how New Mexico has been proactive regarding PFAS?
As a whole, I don't have all the details, but I do know that it was a governor's initiative. I believe the Department of Health has been active, and this commission itself took upon the rulemaking when requested.
So you are familiar with the fact that the governor, Governor Lujan Grisham, advocates for, quote, all New Mexico communities to have reliable access to clean drinking water, unquote.
I don't know that I've reviewed that statement or where that statement came from,
But
but generally that's my understanding.
do you also understand that Governor Lujan Grisham calls for, quote, science-based health standards, and that this policy principle is consistent with both both EMNRD, EMNRD, and the division itself?
I didn't cite any of those speeches. I would take you for what you're saying on it.
But generally, that's what EMNRD follows, as well as OCD, which is science-based health
Correct.
standards.
Correct.
Okay. And that it would be consistent for if the governor says that that's what she wants, which is science-based health standards, that EMNRD and OCD should act consistent with that principle.
Generally, yes.
Are you aware that Governor Lujan Grisham has advocated to, quote, require mandatory disclosure of what chemicals are used in hydraulic fracturing to better protect groundwater, unquote?
I have not seen that statement.
Is it your position that OCD doesn't have regulatory authority to require chemical disclosure except in the instance if an oil and gas company has already violated the PFAS ban by poisoning the water, and then it can mandate disclosure of trade secrets pursuant to OCD's enforcement authority?
Objection, compound, and misstates the record.
And I'm going to join in that objection.
Yeah. Ms. Danesi, where's the basis for that question?
Well, I believe that, well, I can just break it down and ask Mr. Powell.
You can give it another try.
Is it, let's just first start with, is it your position that OCD doesn't have regulatory authority to require chemical disclosure?
I don't think we stated that we don't have regulatory authority to ask for chemical disclosure to the OCD.
Great. Is it your understanding that in the human body, modest tissue concentrations of...
Objection. Again,
I haven't even finished my question.
she's
Madam
asking,
Chair,
well,
so-
she's asking, first of all, she's asking Mr. Powell questions about chemicals in human body tissue. That's not in his direct, nor in his rebuttal that he gave. It's outside the scope of both of those, and I don't believe he's been presented as a toxicologist.
Right, Ms. Danesi, if that's where you're going is human tissues, I think that is outside the scope of Mr. Powell's experience and education.
What is your understanding of the effects that PFAS has had in the human body?
Objection.
Ms. Danesi, I have to ask you to move on.
On page 1 of your direct testimony, you state at line 21, the primary goal of the OCD's modification to the proposed amendments is to ensure that changes are protective. Can you explain why you believe that that is the primary goal?
I think with the rules OCD performs and what we ask the OCC to adopt is generally protective of human health and the environment.
And the reason why you support, to some extent, the PFAS ban is because you believe that that would be more protective of human health. Is that right? And the environment?
Correct.
On page 3 of your direct testimony, you state at line 21, the final but most important change is OCD's proposed definition of PFAS chemicals, as this definition will shape the implementation and effect of the remaining rule changes. OCD attempted to address the PFAS definition using 2 general criteria. First, the definition must be a technical definition to detail what PFAS is chemically, while allowing the division to appropriately implement the definition as the scientific understanding of PFAS continues to develop. Is that your testimony?
Yes, it is.
Is it your testimony that Dr. Hansen's definition of PFAS is not chemically accurate?
Objection. Found it's outside the scope of Mr. Powell's direct.
Yes, sustained.
You stated earlier that you are not a chemistry expert, correct?
Correct.
I noticed on your CV that you had hazardous waste management certification. Is that true?
Yes, roughly 20 years ago.
Are you familiar with the New Mexico's legal definition of hazardous waste?
Objection.
Ms. Anasi, where are you going, or what of his testimony are you referring to?
Well, it was in his CV, and so I'm following up on it.
Okay. He said he had hazardous waste training 20 some years ago. All right. And now you're looking for a definition of hazardous waste?
Well, I could provide that definition to him. I haven't gotten there yet.
Okay. But then what line of questioning would you be pursuing on the basis of that definition?
Well, if he has a certification in hazardous waste management, what I wanted to ask him was if this is the definition of hazardous waste that is has been adopted by the New Mexico legislature, which I would then read, and then I would ask next, does PFAS fall within this definition?
So I'm going to object to any line of questioning about this on multiple grounds. The first of which is it's not in either his direct or his rebuttal. It's also irrelevant. The commission has no jurisdiction over hazardous waste. That rests entirely with the Environmental Improvement Board. And Mr. Powell, while incredibly knowledgeable on a ton of things, has not been qualified here today to speak about hazardous waste. And the fact that he has a HAZWOPER certification does not mean that he's familiar with the New Mexico specific definition of hazardous waste.
And he's not a lawyer. So for all 4 of those reasons, I'm sustaining the objection. Please move on.
I'd like you to refer to OCD Exhibit 11, slide 118. And there is, I'm specifically calling your attention to the 4th line there that states that third-party verified laboratory. Do you see that?
I don't have the slides up. In the bottom right-hand corner, can you tell me what slide number it actually says on the slide? I don't have the exhibit up in the page numbers.
Okay.
I believe I know roughly what you're referencing. I believe it's in Rule 1617. Is that correct?
I'll tell you in 1 minute.
Where it states, and will use a third-party verified laboratory.
Yes.
Okay, I found it.
Would the commission, or sorry, would the division have any objection to changing that language to delete the words third-party verified and insert the word accredited laboratory? or the word laboratory is already there. Just delete third party verified and insert accredited.
I don't have a problem with that as long as OCD is not viewed as that accrediting agency. And with the caveat, I'm not a chemist, so I don't know what accreditations are needed for the methods that we've provided in our definition.
If the OCD bans PFAS as defined by Guardians and the oil and gas industry complies and their chemical constituents disclosures reflect the same, why is it harder for OCD to regulate the oil and gas industry with a narrower definition of PFAS?
Can you restate that question to make sure I fully understand?
I think that on your direct with Mr. Tremaine, you said that it would, if you expanded the definition of PFAS to what Guardians has suggested, that it would be harder to regulate. Do you remember that?
I do. And it would be harder to regulate because there, as discussed by multiple doctors that have set up here so far, there are PFAS compounds that can't currently be tested for using a known method. So with the OCD, we regulate components and rules that we can verify or find violations to without known methods and processes of what to test for. There would be no way to essentially verify whether there was a violation or not a violation without performing that testing. And my understanding is the OCD, other than the error that we're asking to strike, included all the verified methods that are currently available. So the other compounds that haven't been evaluated are not included. Sounds like EPA, based on the last witness, did something similar and eliminated it down to 6 compounds through that process to ensure that it was a verified process. OCD is proposing a larger scope than that, just simply so it can be verified through proven means.
But let me ask you something. I mean, right now, there's lots of chemicals that let me just ask you, strike that. Who determines what is a proprietary chemical or not? The operator, right?
I believe that determination is determined by the chemical company, not the operator.
And so OCD doesn't have that information, correct?
No.
No, OCD doesn't have that information?
Doesn't have
The
what
proprietary information.
we do not have the proprietary information. We haven't asked for the proprietary information.
Right. So in that case, OCD still tries to regulate oil and gas, right?
I would state OCD still does regulate oil and gas.
And so if this division determined that to have the most protective rule, it would adopt Guardian's definition of PFAS, even though not every PFAS compound is known.
Again, I'm not a chemist. I don't know if it would be the most protective to adopt that, because I don't think the literature is out there to state whether those other compounds are studied to see if they're toxic. And I'm not a toxicologist, so I can't get into all of that. That's what the other doctors were for. So I can't say if the other compounds one doctor said it was millions, one doctor said it was 10,000, if those compounds are toxic or not.
Wouldn't more information help the OCD regulate the oil and gas industry?
I think when it comes to PFAS, that's why we define PFAS the way we did, is as more information and more testing methods are proven, they're automatically added to those lists and those methods.
On page 5 of your direct testimony, you state at line 2, the OCD does not support the banning of trademarked chemicals. Did I read that correctly?
Yes.
Unless these trademark chemicals are PFAS, Guardian's proposed rule does not seek the ban of trademark chemicals either.
The way I read Guardian's proposal, it's banning all trademark chemicals because no undisclosed chemicals could be used.
The Guardian's proposed rule change seeks the disclosure of all chemical constituents, but not the banning of what are trademarked chemicals.
I could go in and look, but I believe it says that no undisclosed chemicals could be used in Guardian's proposal.
No further questions.
All right, thank you. Mr. Davis, do you have questions of Mr. Powell?
I do, and I'll just pick right up where that last line of questioning left off. Your understanding is that the proposed rule would ban undisclosed chemicals, correct?
That is my understanding.
Is there anything that you see in the proposed rule that would prohibit a company from voluntarily disclosing a trademarked chemical?
No. With the caveat, the operator typically isn't the one that trademarks. That's the chemical company. So the operator couldn't disclose that without authorization from the company that provided it.
In that situation, the chemical manufacturer would be the holder of the trade secret.
Yes.
So I'll rephrase my question. There's nothing in the proposed rule that prohibits the holder of a trade secret from voluntarily disclosing that trade secret.
Not that I'm aware of.
If the holder of a trade secret voluntarily discloses the chemical identity of a chemical it wants to use in New Mexico, that chemical could then be used because it's no longer undisclosed.
As it was proposed by Wildlife Guardians, that's my understanding of that proposal.
And I'm going to ask you about the Trade Secrets Act, and I don't want to ask you about anything that you don't know regarding the law. But are you familiar with the fact that the Uniform Trade Secrets Act provides a cause of action for the misappropriation of a trade secret?
Objection.
Yeah, Mr. Powell, same instruction as yesterday. If you feel like this is asking you for a legal conclusion, don't go there.
I would simply say I haven't read the Trade Secret Act, and I've relied on our legal counsel to make those determinations.
Fair enough. I'll move on to a different topic. You were asked by Counsel for Namoga about Dr. Brown's testimony. You were present at the hearing when Dr. Brown testified?
I was.
And I believe the question earlier was whether Dr. Brown's testimony was that the DOH or the Department of Health was more appropriate to regulate PFAS. Do you remember that question?
Vaguely. It's been a long day.
Would you agree that Dr. Brown's testimony on that subject was actually that the DOH would be potentially a better agency to communicate chemical disclosure and risk to the public than the OCD?
Objection. I'm sorry. I just have to object here because this is calling for Mr. Powell to speculate on what Dr. Brown actually meant, which I think is inappropriate.
Yeah, would you rephrase, Mr. Davis?
Yeah, I would just respond that the original question from Counsel for Namoga, which I did not object to, was also calling for speculation of what Dr. Brown testified to.
Okay, rephrase this last one if you would.
I'll just move on. We can look at the record of what Dr. Brown said. I won't test your recollection, Mr. Powell. The OCD provided in its exhibit packet some sample frac focus disclosure forms. Do you recall those?
I do.
And these disclosure forms were provided to show that additives other than PFAS are declared as trade secrets?
They were simply to show the commission what's being provided currently through Frac Focus, where the proprietary designations are being used as a whole.
Do you agree that there are chemicals that may be present in frac fluids that are not PFAS, but could be harmful to the environment and public health?
There's chemicals in the Frac Focus link that I wouldn't want to drink that's being reported.
There has been some discussion about the term downhole operations, and I'm just going to ask you a few questions about whether something qualifies in your understanding of what downhole operations are. Are completions part of downhole operations?
Yes.
Are recompletions part of downhole operations?
Yes.
Is treatment of a well part of downhole operations?
Yes.
Is maintenance of a well part of downhole operations?
Yes.
Is drilling part of downhole operations?
Yes.
There was some earlier cross-examination about the term applicable fluid stream in the proposed regulation. Do you recall that testimony?
The proposed testimony for applicable fluid stream, in what part?
I believe Mr. Rankin was asking you about the testing protocols in the proposed rule and whether the testing would be applied to the quote applicable fluid stream.
Yes, I do remember that.
The applicable fluid stream would be the additives that immediately preceded a well integrity event.
Yes.
Is it possible that there would be constituents downhole that were not part of that applicable fluid stream, which could contaminate or pose a risk to groundwater?
There would be contaminants coming from the formation. There would be that are coming up that may not be chemical additives. Is that what you're asking?
Well, I guess what I'm getting at is, could there also be contaminants that were from a prior frac?
I haven't studied it, so I don't know if that would be the case. Typically, when you frac a well, you pressure it up, you open the top, you flow back your frac fluids to a point where then you start flowing back your natural fluids that are in the formation. I don't know how long the frac fluids stay in that well, but the intent is to recover the frac fluids and start producing out the native fluids that's in the formation.
Is it possible that, if I could use the word post flowback, is it possible that post flowback that some of the constituents of the frac fluid may still remain in the well downhole?
I would think so for a period of time, but I don't know what that period of time would be.
How many times can a well be fracked?
There's no limit.
Are wells fracked multiple times?
Yes.
I want to ask you really quickly about CAS numbers. Are you familiar with that term?
I know what a CAS number is, but I don't have a lot of knowledge in that.
And the question I wanted to ask you is whether that's a unique chemical identifier.
Yeah.
It's a number that is assigned to a chemical. You agree that it's a number assigned to a chemical?
Yes.
And if you have that number, you could perform a simple Google search to see what that chemical is.
Yes.
I want to ask you about the Frac Focus database. Is that run by a third party?
It is.
And does OCD maintain the disclosures that are on that website?
We do not.
So if someone wanted to see those disclosures, they couldn't get them from OCD.
They're publicly available.
They would have to go to Frac Focus.
Yes.
If Frac Focus shut down, OCD would not have that information.
OCD could download that information periodically, so they would have access to that information.
Is there any requirement for OCD to periodically download that information now?
I believe there may be, that wasn't part of something I looked at it in this rule, but I believe there was some language about periodically downloading that information, but I don't have that info.
Do you think that may be in OCD's regs?
Potentially, yes.
I'm going to ask you a question that I also asked Dr. Hansen. Do you agree that the purpose of the proposed rule is one of the purposes, strike that. Do you agree that one of the purposes of the proposed rule is to protect groundwater?
Yes.
And do you agree that PFAS could be a threat to groundwater contamination regardless of its source?
Yes.
Do chemicals that are put downhole come back up?
I would assume they would come back up in the fluids that were produced from the well.
So they could come back up and flow back?
Yes.
They could be present in produced water that's brought to the surface?
Yes.
Are flowback and produced water mixed together for purposes of disposal?
Yes.
Could the chemicals that go downhole and come back up be used for enhanced oil recovery?
Yes.
Could they be used for further fracking?
Yes.
Were you in the room during this proceeding when Ms. Troutman testified?
When who? I'm sorry.
Ms. Troutman testified.
Yes, I was.
Do you have any reason to dispute the numbers in her testimony and exhibits?
No.
Again, I'm going to ask you about a Colorado legal provision, and if you are not aware of it, just tell me. Okay. Are you familiar with the Colorado law that requires chemical disclosure of chemicals used in downhole operations?
I am not.
Okay. Are you familiar with the California chemical disclosure law?
The only statements is what I heard here earlier, that both of those were done through legislation.
Your knowledge of those laws is just from what you've heard during this hearing?
Yes.
You testified that OCD is concerned about the implications of holding proprietary information as that relates to the Inspection of Public Records Act, correct?
Can you state that again to make sure I fully understand?
Sure. There were some questions earlier today, I believe from OCD Council, about the numbers of disclosures that OCD would have to retain under Guardian's proposed rule. Do you recall that?
I do. I believe council was stating that if OCD received those records and an IPRA was conveyed on those, OCD would have to make a determination whether those were or were not trade secret.
And in that line of questioning, I believe that OSHA regulations at 29 CFR 1910.1200 were mentioned, and that's related to safety data sheets.
I don't remember discussing OSHA sheets.
Are you familiar with safety data sheets?
At a high level, and not with the regulations that surround them.
Are you aware that there is also a provision for maintaining confidentiality of proprietary information on those sheets?
I would take your word for it.
There was some testimony earlier today about administrative burden related to retention of those records that we just talked about. If Guardians removed the provision in the proposed rule for chemical disclosure lists, and the disclosures were all made to frac focus, meaning OCD would not retain the actual chemical disclosure list, would that ease your concern of administrative burden?
We actually approached Frac Focus to see if that was possible. And being a third party, they do not do that for any other states, is our understanding, as far as keeping proprietary information in that avenue.
And I'm gonna so I'm gonna ask you to make an assumption that Guardian's proposed rule related to the ban of undisclosed chemicals was promulgated. In that situation, there would be no proprietary information on Frac Focus because it would be voluntarily disclosed. So making that assumption, if OCD was not holding the chemical disclosure lists and receiving that information, and instead the discloser was providing it to Frac Focus, would that ease your concerns of administrative burden?
I believe there would be no administrative burden as far as holding that, because it would be effectively eliminating the proprietary information.
And then I would have the same question about your IPRA concerns. Would that also alleviate or resolve your IPRA concerns?
Well, there would be no data to hold.
Thank you. I want to ask you about 19.15.16.17A2. And if anybody in the room can recall that from memory, I'm going to guess it's you. But this is the part of the proposed rule that talks about the loss of integrity and disclosure in the event that there's a loss of integrity for testing purposes. Do you agree that I'm in the right section here?
Yeah, as proposed.
I just want to ask you if these provisions, strike that. Are you familiar with the recent events in West Texas and the Permian Basin where there have been well blowouts related to injection activities?
I believe there have been well issues. I have not studied those to what caused them or what effects they've had.
Would the provisions of the proposed provisions of 19.15.16.17A2 apply in the event of a well blowout?
As we discussed earlier, a well blowout being an integrity loss downhole that we discussed earlier, then as proposed A2 would apply to those scenarios.
And would it also apply to the loss of integrity of a plugged well?
For a plugged well, the way it's defined at the top, both in Wild Earth Guardians and OCDs, it's if damage from shooting, fracturing, or treating of a well has the potential to impact. A plugged well, I don't believe would be treated at that point, so I don't know that a plugged well would apply.
Thank you for that clarification. And just to clarify, I think I know the answer to this, but that section also would not apply to any spills that potentially affect freshwater resources.
State that again, I apologize.
Sure. The same section we're talking about, loss of a well integrity. That does not, those proposed provisions do not apply to spills that affect groundwater or freshwater courses.
Unless the spill happens because of a loss of integrity.
If an operator requests proprietary chemical information from a manufacturer and the manufacturer refuses to provide that information to the operator, does OCD have the ability to get that information from a manufacturer?
I would have to check with OCD's legal counsel, but OCD does have subpoena power, and at that point, there would be a threat to water.
Last question. Is there currently any regulatory restriction that you know of that prevents a company from using PFAS in future downhole operations?
Currently or after this?
Currently.
No.
And I said that was my last question, and it was. Thank you so much, Mr. Powell.
Thank you.
Right. Oops, thank you, Mr. Davis. Mr. Tremaine, do you have any redirect before I go to the commission?
I just have a couple questions. They'll be very quick. Thank you, Mr. Powell. Briefly, in your testimony today, you've had some questions about produced water reuse and potential PFAS in produced water. So I want to ask you generally, like, how much produced water was reused in oil and gas operations in New Mexico in 2024?
So far this year, there's been approximately 7 billion barrels reused.
Is that a B?
Yes.
Billion? Reused. Okay.
Or not, let me correct that. It's 7 billion gallons, not barrels, because the water use report is in gallons.
Thank you for that clarification. So barrels would be what, 7 billion divided by 40? Is that correct?
42.
40. Okay. I shouldn't even have tried. Should have just asked.
Even I know that.
Lawyer math. Do you know what percentage of total strike that. Do you know what percentage of total injected water was injected for completions volumes?
I don't know the total volume, but I know produced water accounts for roughly 50 to 70% of what's injected. So you could extrapolate that out. You're probably looking at 10 to 12 billion gallons that's injected, just rough numbers.
Okay. I think, so just to clarify, because I butchered my question, I was asking you for the percentage of water that is injected that was reused. Do I understand that you answered that as 50 to 70?
Yeah, generally it to my knowledge, the last couple of years, it's averaged between 50 and 70%.
Okay. If produced water was not available for use in downhole operations, what would an operator have to do with it?
Inject it downhole in an injection well.
And if operators chose not to use produced water, what would they use instead of produced water?
Typically, I believe before we started reusing produced water, it was using freshwater supplies.
No further questions.
Okay, thank you, Mr. Tremaine. Mr. Chair, do you have questions of Mr. Powell?
Madam Hearing Examiner, may we take just a few minute break?
Absolutely. Let's take 10 minutes.
Thank you.
Okay. Is this, oh, now it's on. Thank you for running, Jerry. All right, thank you. All right, we are back after a short break. And when you get back to your chair, I'm going to invite you to ask questions of Mr. Powell.
Thank you, Madam Hearing Officer, and thank you, Mr. Powell, for your testimony today. We appreciate it. I just have a few questions. Yesterday, there was some concern that came up about being able to test for PFAS even in the future. And I believe you had said that if in the future there was some necessity to be able to do some testing on an area and we found PFAS, we would keep the original operator of the well or the last operator of the well or whoever it was that caused the spill responsible. Can you go into that a little bit for us, please?
Yes, thank you for asking that. It probably needs to be elaborated a little bit further. So as far as this rule that we're asking, the initial testing would be at the time of the well integrity event. If things are found in the waters later, as far as part of a groundwater cleanup, groundwater investigation, that would happen under 29 and 30. So it wouldn't necessarily be under this rule. It would be under a separate set of rule. This rule, the way it's spelled out, would be looking for that initial wellbore integrity event and would be identifying the chemicals as written in this rule at that time. If things are looked for or found later, that would more than likely happen under Part 29 or Part 30 investigations.
Okay. Okay. Thank you for clarifying that one. Then there's a lot of conversation about the PFAS definition. And again, just so I understand, and I think so the commission understands, the PFAS definition that has been proposed by the OCD is basically a two-part definition, if I kind of understand it correctly. The first part is the actual definition that chemists use across the world about what PFAS is. Is that a fair statement?
Yes.
Okay. And then the second part is how the OCD would be able to implement PFAS after testing, correct?
Correct.
Okay. So the notion that the OCD is precluding single carbon compounds that are perfluorinated is really not true. It's there. It's just right now the OCD wouldn't be able to see it in its testing protocols.
I think the way the definition is there would be a preclusion of things you can't test for at this point.
Okay.
In an attempt to not be arbitrary in what that definition would encompass, because we wouldn't want to encompass something that hasn't been founded, hasn't been at least studied to a certain extent, and can't be tested reliably. And so if there's a concern that comes up or something that you need to test for, we want to be able to test for that.
Okay. Thank you. I know it's been mentioned that you're not a chemist, you're not a toxicologist or any of that, but you are a regulator and you are the deputy director of the Oil Conservation Division. So help this body understand how the way that the definition and the changes, just so we hear it in your voice, we saw it in your PowerPoints and stuff, but how does all of this help us make this decision on which way to go? Why is the OCDs the more well-rounded?
So as far as in actual implementation of it is why OCD is looking there. So if you have a wellbore integrity event, you're going to ask for all of that information for the chemicals that are used in that. You're going to identify what chemicals are used in that, and then you're going to go test for those chemicals. With having chemicals you can't test for, it would be difficult to identify what chemicals to test for in performing that evaluation. So having what chemicals were used and then comparing them to a method that can be tested for is necessary to identify those potentially harmful chemicals to then transition into the other parts of the OCD's rules and their applicability. So in identifying those early chemicals, if you identify something, you would have a method to test for.
Okay. Okay. Thank you. And testing, and it did pique my interest as well. The OCD submitted that it would be a verified third party. Currently, does the OCD use that phrase, verified third party laboratory?
I don't believe so. I think we provide methods, but I don't know if that's included in Part 29 or not.
Okay. That may be something that the OCD may want to look into. Maybe rewording.
Typically, when we receive the results, we look at what's supplied with the results. We ensure that background, the blanks, those kind of things are relayed. So if there is questions, we can look at those qualifiers. But we don't ask for the accreditation because I don't know if, well, the OCD doesn't oversee any of those accreditations.
Okay. Great. Thank you. And I must admit, I apologize, Mr. Davis, your questions sometimes were a little compounded. I was having a hard time following. So please also jump in if I've got the question wrong on this or what was said. Mr. Davis had asked you about 19.15.16. Let me just start that over. He asked you about 19.15.16.17.A2. And that particular one is the one where WEG proposed it starts off, if damage from a shooting, fracturing, or treating of a well has the potential to impact surface or groundwater. And Mr. Davis asked you something along the lines about blowout affecting fresh and groundwater. And I must admit, I missed the answer. Do you by any chance remember what the question was, and do you remember the answer?
I believe the response was if there was a well integrity event, and that's what I believe he was elaborating to as a blowout. If it affected surface water or fresh water, would this rule apply during production, those kind of things? And the answer was yes.
Okay. I wrote down, does it apply or not with a question mark? So thank you for answering. No further questions for me. I appreciate it. Thank you, Mr. Powell.
Thank you.
Thank you. Commissioner Bloom.
All right. Good afternoon, Mr. Powell.
Good afternoon.
It's been a long day. Thank you for your testimony and sticking with this. First, we wanted to look at this question of management of disposition or generation of waste. It's been brought up. If the OCD, would you agree that the OCD regulates the disposition of produced water?
We do.
Do you believe that the OCC can regulate PFAS in produced water?
We do.
I'll leave that there. There was an issue about notice that was brought up. And I don't remember if it was brought up by Mr. Tremaine, so I'll ask you, but did OCD say in its opening that the OCC should not rethink this? Strike that.
I believe I know what you're asking if you'd like me to answer.
Yeah, please go ahead. Thank you.
The OCD, when we started, and I believe in Jesse's opening statement, didn't feel like the downhole operations as a whole, so drilling other production operations had been noticed. In re-reviewing the language from Wild Earth Guardians, they did use downhole operations. It was the OCD that had changed that to completion and recompletion because that's the extent of a lot of the conversations circled around. So there was a misunderstanding there, whether downhole operations as a whole and whether they encompass drilling or production operations were encompassed. After further evaluation, as this was ongoing, we feel that that was noticed properly.
Okay. And actually, I think it was a different issue that I was thinking of. I was going to ask about that one as well, so thank you. But did Mr. Tremaine say in his opening, or is it the OCD's belief that the OCC in this hearing process shouldn't get into issues related to disclosure of other chemicals besides PFAS?
Boy, I don't remember that in OCD's proposed language. If there is a well integrity event, we would be looking for disclosure of all chemicals used in the well.
Okay. And I think specifically my question was more along the lines of, did the OCD believe that Guardians properly noticed this? And I looked at the notice and saw that it said there are 2 points, and the second one said, quote, that the commission adopt new chemical disclosure and reporting rules to ensure reasonable transparency around substances used by the oil and gas industry and to ensure industry compliance with the prohibition on the use of PFAS.
This may be a better question to ask Jesse if you're asking if he stated it, but I believe OCD is under the assumption that that's what Wild Earth Guardians was asking, was full disclosures.
Okay, thank you. I don't know, Mr. Tremaine, if you had anything to add there, if that's proper to ask you.
Yeah. Well, I mean, if you're asking me, I'll answer. Commissioner Bloom, I think it's possible that I misspoke in the opening. It's possible. I mean, we can go back to the record. I think OCD's position, I think there's a couple of different things going on. One, OCD's position was that notice, we did not support notice to like third parties that OCD has not communicated with and that OCD does not regulate. To the proprietary question, OCD was supporting potentially upon triggering events, disclosure of all proprietary information to the OCD. OCD is taking a position that it is arguably in conflict with state statute to require disclosure of proprietary information to the public. So there's a distinction there. Did that answer your question?
I think so. And it led to my next question. So thank you.
And Commissioner Bloom, if I may, if you have any questions about Guardian's position on this matter, I'm happy to articulate it.
Please go ahead.
So there has been some question about whether Guardians is requesting the banning of undisclosed chemicals on the oil field in addition to PFAS. The answer to that is yes. And the way that would work is that Guardians is not asking for a specific ban on any chemical other than PFAS, but we are requesting that if you will not disclose those chemicals or you cannot get the chemical identities from the manufacturer, for instance, then you just simply can't use that in New Mexico. So in effect, it would mean that all chemicals used downhole are disclosed.
Very good. Thank you. As I reread this morning, the New Mexico law for uniform trade secrets, Chapter 57, Article 3A, and it's 7 short paragraphs. And I didn't see anything in there suggesting that rulemaking by this body or others couldn't ban the use of undisclosed and or trade secreted chemicals. My understanding is that we can't force anyone to reveal trade secret chemicals, but it doesn't mean that the OCC can't prohibit the use of undisclosed chemicals. Does OCD see this differently, Mr. Powell?
I think where OCD was coming from when it's talking about undisclosed chemicals is there's chemicals outside of PFAS that could be used downhole that operators have declared as proprietary. I believe on the examples that were provided, mineral oil was one of them. That's non-PFAS containing. We don't feel that that's a chemical we're looking at today of banning, but it would effectively ban that unless that chemical provider would provide that information. OCD is also seeing things like special grit sands that an operator is using that they've requested proprietary knowledge on because the grit of the sand is better. So there's things that have been declared as proprietary that we feel aren't harmful to the environment and therefore shouldn't be banned. And it was OCD's stance that we felt that at this level, if we were banning trademark chemicals, it may not be explicit in the statute, but that would be an effect that could be large